May I please, Your Lordship? I beg to mention item number 24. Let this matter must be come after one.
Any objection? On pre-made by the appellant, this is matter up to 3 weeks.
May I please, Your Lordship? I beg to mention item number 22. Your Lordship, this matter will be listed after 2 weeks.
On pre-made by the appellant, this is matter up to 3 weeks.
Obliged, Lordship.
May it please, Your Lordship. Lordship, I beg to make a mention in item number 20, Your Lordship.
20.
Yes, Your Lordship. 20. Lordship, I'm praying for some accommodation, Your Lordship, since a senior counsel is not keeping well, Your Lordship.
For the respondent, Your Lordship.
Any objection?
No objection, Lordship.
On pre-made by the petitioner, this is matter up to 3 weeks.
Obliged, Your Lordship.
Lordship, similar prayer for item number 21, Your Lordship. 21.
This matter has been pending for quite some time.
But in view of the pending proceedings before this court, now the suit has not proceeded. This is a very simple matter actually. Anyway, since his senior is not well, I will not object. But an endeavour should be made after 2 weeks that the matter be disposed of.
So how long?
2 weeks, Your Lordship.
On pre-made by the respondent, not objected to by the petitioner, this is matter of the 2 weeks.
Similar prayer for item 23, Your Lordship.
On pre-made by petitioner, this is matter of the 3 weeks.
I oblige, Your Lordship.
Good afternoon, Your Lordship. Your Lordship, we are for the petitioner. We were supposed to file our rejoinder, Your Lordship. But in the meantime, the petitioner, he's been hospitalized. He's not keeping well, Your Lordship.
On pre-admit by petitioner seeking some more time to file the rejoinder affidavit.
Kindly allow for 2 weeks, Your
Matter is
Lordship.
adjourned. This is after 2 weeks.
Kindly oblige, Your Lordship.
Item number 5.
May please your lordship. My lord, this petition under section 482, my lord, CRPC, whereby praying for quashing of the FIR and all the proceedings thereafter, including the charge sheets, my lord, and on the basis of a compromise that has been arised,
307 matter.
my lord, 307 matter, my lord. So on the basis of the compromise arrived between the parties, my lord, the parties involved here are the father-in-law and a son-in-law, and the altercation happened because of one cat, a kitten, so to say, my lord. And in the process, my lord, thereafter, my brother-in-law filed the FIR. But anyway, my lord, will not go into the merit of the case now. And the only question that remains here is, because section 307, an attempt to a murder, which is a non-compoundable offence, has been attracted. So whether 482, in exercise of 482, an offence under section 307 can be quashed or not on the basis of a compromise, or rather because 307 is considered as a heinous, so can't such offence can be compromised between the party or not, my lord. That is the only question that needs to be determined before my lord. So and that is also the only questions, that the objections that has been raised by the prosecutions also, my lord. The parties are here, the respondents are here, my father-in-law, my brother-in-law, the so-called victim, and also the complainant are all here, serve notice, my lord. My lord, before I go to the showing, my lord, some judgments, my lord, where the Honorable Supreme Court and also other high courts have allowed, even this court has allowed, my lord, quashing of 307, my lord. Now, quashing of 307, my lord, depends from cases to cases, my lord. It has to be examined from cases to cases and from circumstances to circumstances, that my lord is very much aware. Now, the inherent power, my lord, of the High Court to quash a non-compoundable offence was not circumscribed, my lord, or is not been limited by any of the provisions of the court, my lord. In even section 320 does not limit it, my lord, because section 482, my lord, it itself is a declaration of the inherent power of the court, so long as the exercise of the inherent power falls within the parameters of section 482, my lord. So that is the inherent, that is the declaration itself given to the power of the to the court, my lord. So section, it has all the overriding effect over all any other provisions, my lord, of section 320 we call it, or 482, my lord. It has itself as in overriding effects, my lord. Now, therefore, my lord, depending on the circumstances, as I just repeat myself, my lord, the High Court can exercise 482 and quash, my lord. Now, in this matter, my lord, I'll just like to refer to two judgments, my lord, where the first judgment, my lord, it's Gyan Singh. Of course, my lord, Gyan Singh has been relied by many of the judgments, my lord, while quashing of this kind of nature, my lord. I would like to refer to, my lord, one of the case reported in 2013-11 SEC 497. You got it? 497, my lord. My lord. There's a parties are Dimpe Gujral, wife of Vivek Gujral, and others versus Union Territory through Administrator UP Chandigarh and others, my lord. Here, in this also, my lord, section 307 was attracted, my lord. 307, and apart from that, so many other sections like rioting and so on and so forth, my lord. But what is concerned is 307 here also, my lord. And in this one, the court says that even in 307, there are different natures of cases, and nature of cases that affects the society. And at the same time, there are cases, nature of cases that affects personal, in person, my lord. Here, now I am fighting over a sword, over a dao with my father-in-law. In this struggle, I get injured, my father-in-law gets injured. It's between two individuals. And we are in somewhere in the intoxication state of mood also. So now, even if 307 is attracted here, can we say that it was an offense against the society? Injured, both of us are injured. So therefore, in this kind of cases, my lord, 307 can be quashed. This is what is this court, this case talks about, my lord. So
Any specific paragraph?
yes, my lord. Paragraph number 6, my lord. Paragraph number 6. May I read, my lord? It's a very small paragraph. The question which now remains to be answered is whether, since one of the offenses alleged in the FIR is non-compoundable, the FIR could be quashed. In certain decision of this court, in view of the settlement arrived at by the parties, this court quashed the FIRs, though some of the offenses were non-compoundable.
Just you're reading? Para 6.
Para 6, now I'm going to paragraph 7, my lord.
Where is it? Oh, yes.
My lord. So, paragraph 7, I am starting to read from there, my lord. In certain decisions of this court, in view of the settlement arrived at by the parties, this court quashed the FIRs, though some of the offences were non-compoundable. A two-judge bench of this court doubted the correctness of those decisions. The learned judges felt that in those decisions, this court had permitted compounding of non-compoundable offences. The said issue was therefore referred to a larger bench. The larger bench in Gyan Singh versus State of Punjab considered the relevant provisions of the court and the judgment of this court and concluded as under. Paragraph 61, my lord, there's a quotation. The position that emerges from the above decision can be summarized thus. The power of the High Court in quashing a criminal proceedings or FIR or complaint in exercise of its inherent jurisdiction is distinct and different from the power given to a criminal court for compounding the offences under section 320 of the Code. Inherent power is wide plenitude with no statutory limitation, but it has to be exercised in accord with a guideline engrafted in such power, namely, to secure ends of justice or to prevent abuse of the process of any court. In what cases power to quash the criminal proceedings or complaint or FIR may be exercised, where the offender and the victim have settled their dispute, would depend on the facts and circumstances of each case, and no category can be prescribed. However, before exercise of such power, the High Court must have due regard to the nature and gravity of the crime. Heinous and serious offences of mental depravity or offences like murder, rape, dacoity, etc. cannot be fittingly quashed even though the victim or the victim's family and the offender have settled the dispute. Such offences are not private in nature and have a serious impact on society. Similarly, any compromise between the victim and the offender in relation to offences under special statutes like Prevention of Corruption Act or offences committed by public servants while working in that capacity, etc. cannot be provided for any basis for quashing criminal proceedings involving such offences. But the criminal cases having overwhelming and predominantly civil flavor stand on a different footing for the purpose of quashing particularly the offences arising from commercial, financial, mercantile, civil, partnership or such like transactions, or offences arising out of matrimonial relating to dowry, etc. or the family disputes where the wrong is specifically private or personal in nature, and the parties have resolved their entire dispute in this category case. The High Court may quash the criminal proceedings if, in its view, because of the compromise between the offender and the victim, the possibility of conviction is remote and bleak, and continuation of the criminal cases would put the accused to great oppression and prejudice, and extremely injustice would be caused to him by not quashing the criminal case despite full and complete settlement and compromise with the victim. In other words, the High Court must consider whether it would be unfair or contrary to the interest of justice to continue with the criminal proceedings, or continuation of the criminal proceedings would tantamount to abuse of the process of law despite settlement and compromise between the victim and a wrongdoer, and whether to secure the ends of justice. It is appropriate that the criminal case is put to an end, and if the answer to the above question is in the affirmative, the High Court shall be well within its jurisdiction to quash the criminal proceedings. So in light of this one, my lord, even in this case was quashed. Now, my lord, just reflecting a very back to my lord, how did the incident had happened, my lord? The incident had happened because my version of the story, my lord, and which is reflected, is that I was going to my field. I was carrying my dhow, because it's a customary to, when you are going to the jungle to clear up, to go for the jum or to go for brie, we call it. You carry dhow. So I saw father-in-law playing with my cat. What's my cat? I asked him back. He threw the cat in the bushes. That's where the altercation happened between us. And there, both of us were injured in that process, my lord. And at the end of the day, this is a family matter. We have settled the differences between us. Medical report will go to show that the accused was more injured than the victim also. But besides that, my lord, what is important is that the compromise has been arose between the parties, and this case is at a nascent stage of the trial also, my lord. The evidence has not yet started also, my lord. Now, the compromise deed, my lord, if I may, for page 86 is the compromise deed, my lord, that has been entered between us, my lord, between all the three parties, my lord. Page 86, my lord. This has been duly notarized also, my lord, this compromise deed. My lord, this is executed by three parties, my lord: the complainant, the victim, and me, my lord. This is executed on 23rd day of March, my lord. And where was from the third paragraph onwards, what he said is, the complainant, out of anger and in a moment of heat, filed an FIR against his own brother-in-law at Mokorwat police station on 7/8/2016, and the police subsequently registered the complaint as Mokorwat PS case number so and so under section 307/326 of the IPC against the accused person. And whereas the case is charge sheeted and pending for trial before the court of the district and session judge Mokorwat under so and so. And whereas the complainant and the victim, being the brother-in-law and father-in-law to the accused person, realize the fault of filing an FIR against the accused person, despite the case is purely by mistaken and with interference from the family members, settle down the case amicably and forgive each other unconditionally. Therefore, the first party is no longer interested to pursue the case against the second party, and since the case is amicably settled, therefore they do not want the case to proceed ahead, as they might torn the family apart. And whereas the complainant and the victim, being the brother-in-law, father respectively, and the close relatives to the accused person, and out of respect agrees to forgive the accused person, and both the parties agree to sign the present compromise deed unconditionally. And whereas the complainant and the victim agrees that they do not want to pursue the case pending before the trial court, so and so, so and so, so my lord, there is not a single piece to even suggest that it has been coerced. This has come out willingly, looking at the relationship that they share between. At the end of the day, I am the son-in-law, I am the brother-in-law, the husband of the daughter, the husband of the sister, my lord. So for the benefit of the family, my lord, that's why this compromise deed was being executed also, my lord. So, my lord, I have shown one judgment, my lord, where my lord has the power, and I says that no provision of CRPC can override the power of the inherent power of section 482 from this honorable court, depending on the facts and circumstances of the case, my lord. And there is one more case, my lord, which I will not read, but I will just point it out, and then this one, yes. The Supreme Court judgment is there. This one, yes. This one. There's one more case, my lord, 2014, 6 SEC 466, my lord, Narendra Singh and others. Where is the paragraph? And the relevant paragraph would be, my lord, just note it for my lord's this convenience only, 29.2, my lord, 29.2 and 29.6, 29.7, 29.7 and paragraph 33.
Better copy.
My lord,
See this one, can't read.
oh, I'm so sorry, my lord.
We'll get it.
Yes, I think.
We have, may it please your lordship. Lordship, in fact, we have submitted the list of book, your lordship. That judgment has been reflected in 2019 5 SEC page 57, your lordship, at paragraph 16.2 of that judgment, your lordship.
But
Narendra Singh, no? You are putting
Narendra Singh is there. But
Narendra
then
Singh, no?
paragraph 29.
Yes, my lord. 29.2, 29.2, 29.6.
Yes, your lordship. In that judgment, you will find it, your lordship. Yes. 2019 5 SEC. State of Madhya Pradesh versus Dhruv Gujar and another.
And also, my lord,
Just which paragraph?
my lord,
that lordship will find it in it start from paragraph 16.2, your lordship, at page 580 of that 2019 5 judgment, your lordship.
Okay.
Then lordship, that has been Ginseng, the authority of Ginseng, Narendra. Then lordship, lordship that then which my friend has quoted, then 582, your lordship, 29.6.
and one more judgment that I would like to refer, my lord. I'll just give the citations, my lord, no read. That is 2012 10 SEC 303 paragraph 61. Gyan Singh versus State of Punjab.
That has been referred in that judgment.
Para 61, my lord. So,
Come again, that Gyan Singh.
Gyan Singh is 2012 10 SEC 303 paragraph 61.
Yes.
So, my lord, I raise my submissions here, my lord, and crave leave if any rebuttal has to be done. Rejoinder, my lord, I crave leave, my lord.
I may please your lordship. Lordship, kindly turn to the FIR, your lordship, which is at page 15, your lordship. The type copy is at page 16. The incident took place, your lordship, in the residence of the victim, your lordship.
Yes.
Lordship. Then, lordship, the lordship kindly see the nature of injuries sustained by the victim, your lordship. Lordship will find it at page 42, your lordship. It is a stab injury, your lordship, in the vital part of the body, your lordship. Lordship, though the type copy is there, your lordship, but it's not clear, your lordship. 43 is the type copy. Lordship, kindly refer to the handwritten of the medical officer. Page 42, your lordship.
Yes.
Lordship, kindly see stab injury to Lordship, I can also on the left side of abdomen and bleeding, Your Lordship. So, Your Lordship, abdomen, in my humble and respectful submission, Your Lordship, is the vital part of the life of a person, Your Lordship. Lordship is can read, Your Lordship, that what perish, Your Lordship, very difficult to read, Your Lordship.
This is page 42, isn't it?
Lordship, yes. That is diction link.
Authorisation.
Lordship, yes. Lordship, can you see on the left side of the abdomen, Your Lordship? So abdomen, Your Lordship, is a vital part of the life of a person, Your Lordship. Then, Lordship, the contention that they were drunk, Your Lordship, that is negated by the medical report, Your Lordship. Your Lordship will find at page 45. Lordship will find at column number 17. 16, Your Lordship, kindly come to 16, Your Lordship.
45.
Lordship, yes, at page 45. That is the
medical report.
Lordship, yes. No external injury, not Lordship, for
Where is it?
Lordship, at page 45.
Yes.
46, I'm sorry, Your Lordship, page 46.
Yes.
Then, Lordship, no external injury, nor, Lordship, I can read also that one. Then no alcohol breath, Your Lordship. So the condition that they were drunk, no, that is negated, has been not by the medical evidence, Your Lordship. Then, Lordship, kindly come to the seizure list. What is the weapon use? Lordship, kindly come to page 73. Lordship, page 73, Your Lordship. This is a dao kukri, maybe a Dakar, Your Lordship, made of iron, length 20 inches, including 6 inches of wooden and 2 inches wide, Your Lordship. So, Your Lordship, kindly see the dao, the kukri, Your Lordship. Kukri means, Your Lordship, maybe it's a Dakar, Your Lordship. So, Your Lordship, it's a dangerous weapon, Your Lordship. It's a dangerous weapon, Your Lordship. So, Lordship, 307, Your Lordship, cannot be compoundable, Your Lordship, but there is no legal quarrel, Your Lordship, as to the application of Section 482, Your Lordship. Your Lordship will have to see the fact and circumstances of the case, Your Lordship, which I'm going to place before Your Lordship. That it cannot be done, Your Lordship. This is a crime against the society. It is not a crime against a person. It is a crime. It is a crime against the society, Your Lordship. And kindly see this nature of the portion of where the person has been stabbed, Your Lordship, and then the weapon used, Your Lordship. So it cannot be. It cannot be, Your Lordship. It cannot be, Your Lordship. Lordship, first I would like to please the judgment of the Delhi High Court, Your Lordship. This is 2021, Your Lordship. SEC online, page 4428, Lordship.
Four.
4428, Your Lordship. Why am I quoting, Your Lordship, this one? Because Your Lordship, kindly come to para 9. Para 9. In 2014, Your Lordship, that is in the case of State of Rajasthan, Shambhu Kewat, Your Lordship.
Para 9.
Para 9, Lordship, kindly come to para 9.
Present case.
Lordship, yes. What happened, Your Lordship? In that case, some court say no, it cannot be quashed. It cannot be quashed. And then, Lordship, it has been noticed subsequently in Narinder Singh versus State of Punjab. Lordship, kindly come to 10. Lordship, I'm sorry. In Shambhu, in the case of Shambhu, Your Lordship, then what happened? The two judges, that has been referred to a constitution bench, Your Lordship, para 10, Your Lordship.
Yes.
Then, Lordship, kindly come to the next page, Your Lordship. Next page, Lordship, in para 11, Your Lordship. So there is a conflicting judgment. Then the matter was settled by the larger bench, Your Lordship, in the state of Madhya Pradesh versus Lakshmi Narayan It's reported in 2019 5 SCC 688, Your Lordship. Kindly see, Your Lordship, 15.4. Lordship is with me. In para 11, Your Lordship,
Yes.
of that judgment. Then, Lordship, that has been settled by the Constitution Bench, Your Lordship, in State of MP versus Lakshmi Narayan. Then what? Then, Lordship, it's observed like this. Paragraph 15.4, offences under Section 307 IPC at the Arms Act would fall the category of heinous and serious offences, and therefore are to be treated as crime against the society and not against the individual alone. And therefore, the criminal proceeding for the offence under Section 307 IPC and or the Arms Act, which have a serious impact on the society, cannot be quashed in exercise of power under Section 482 of the Code, on the ground that the parties have resolved the entire dispute amongst themselves. However, the High Court would not rest its decision merely because there is a mention of Section 307 IPC in the FIR or the charge is framed under this provision. It would be open to the High Court to examine as to whether incorporation of Section 307 IPC is there for the sake of it, or the prosecution has collected sufficient evidence which is proof would lead to framing of charge under Section 307. For this purpose, it would be open to the High Court to go by the nature of injury sustained, whether such injury inflicted on the vital, delicate part of the body, nature of the weapon used, etc. However, such an exercise by the High Court would be permissible only after the evidence is collected, after investigation and the charge sheet is filed, charge is framed, and or during the trial. Such exercise is not permissible when the matter is still under investigation. Therefore, the ultimate conclusion in para 29.6, 29.7 of the decision of this court in Narendra Singh, Lordship, that is what my friend has also quoted, should read harmoniously and to be read as a whole and in the circumstances stated herein. So, Lordship, kindly come then para 13 of that. Lordship, I'll come straight to para 14. The victim has been attacked with a dangerous weapon, a knife, as stated above, injuries, Lordship.
Yes.
So knife is a knife, Your Lordship. In this case, in the Delhi High Court, the injury was caused by a knife, but in the present case, Your Lordship, by a dagger, Your Lordship. Then another point I would like to inform this submit, Your Lordship. This case, Your Lordship, it has been charge sheeted, and the trial is going on before the learned session judge at Maukarat, Your Lordship. On 9/3/2022, Your Lordship, a charge has been framed and the accused has pleaded guilty, Your Lordship.
Yes.
Then, Your Lordship, on 2/5/2023, Your Lordship, the informant has been examined by the learned trial court, Your Lordship.
Yes.
Then, Lordship, another decision also I would like to. Lordship, kindly come to another one, Your Lordship. This is 2019-4 SCC, page 268, Your Lordship, paragraph 5 and 6. 2019-4 SCC, Your Lordship, 268. Lordship, kindly come to paragraph 5 and 6.
Yes.
May I read it, Your Lordship?
Please.
It is required to be noted that the original accused was facing the criminal proceeding under Section 307, read with Section 34. It is not in dispute that as per Section 320, offences under Section 307, 294, read with Section 34 are non-compatible. It is also required to be noted that the allegation in the complaint for the offence under read with also are such very serious. It is alleged that the accused fired, Lordship, that is the fact of the case. Then, Lordship, kindly come to paragraph 6. At this state, the decision of this court in Kulab Das versus State of UP is required to be referred. In the set, this court has basically observed that held that despite any settlement between the complainant on the one hand and the accused on the other hand, the criminal proceeding for the offence under Section 307 IPC cannot be quashed, as the offence under section is a non-compatible offence. Under the circumstances, the impugned judgment and order passed by the High Court quashing the criminal so-and-so is not cannot be sustained, and same deserve to be quashed and set aside. So, Lordship, this decision support my case, Your Lordship, that the section under 307, Your Lordship, cannot be compounded. Then, Lordship, another one, Your Lordship, that is 2015 8 SCC 307. 2015 8 SCC, Your Lordship, 307. Lordship, kindly come to paragraph 5. This is the in this case, Your Lordship, the Ginseng judgment has been cited, Your Lordship, in paragraph 61, which my friend has referred to, Your Lordship. So I'll not read that, Your Lordship. And then kindly come to paragraph 6, Your Lordship, of that judgment. When we apply, Lordship is with me.
Yes.
When we apply the principles set therein, it can be stated that when it comes to the question of compounding an offence under section 307, Lordship, I will not read that amsang, by no stretch of imagination can it be held to be an offence as between private parties simpliciter, inasmuch as offences will have a serious impact on the society at large. It runs beyond our comprehension to state that after the commission of such offence, the parties involved have reached a settlement, and therefore such settlement can be given a seal of approval by the judicial forum. Then, Lordship, the last citation, Your Lordship, is 2019, Your Lordship, volume 5 SEC, page 570, Your Lordship.
2019 5.
2019 5 SEC, Lordship, 570. Lordship, I'll take 570. Lordship, I'll take Lordship to paragraph 16.2. Lordship, in this judgment also, the authority of Ginseng also has been referred to, Your Lordship. Ginseng, Your Lordship. Same para 61, Your Lordship.
Yes.
Then, Lordship, will kindly come to para 16.6. Lordship, has been recorded, the Lordship, that is, I'll emphasize, Your Lordship, in paragraph 29.6. 29.6, Your Lordship, which is in the next,
Yes.
at page 582, Your Lordship. Offences under section 30 would fall in the category of heinous and of Lordship. That is has been reiterated by the Honorable Supreme Court, Your Lordship. That is a serious offence and therefore cannot be compounded. Then, Lordship, kindly come to 16.4 at page 583.
Yes.
In so and so, again, this court had an occasion to consider whether the High Court can quash the FIR complaint criminal proceeding in exercise of the inherent jurisdiction under 482. Considering the category of decision of this court on the point, this court summarized the following proposition. 482 CRPC preserved the inherent power of the High Court to prevent an abuse of the process of any court or to secure the end of justice. The provision does not confer new power. It is only recognize and preserve power which is inherent in the High Court. The invocation of the jurisdiction of the High Court to quash a false information report or a criminal proceeding on the ground that the settlement has been arrived at between the offender and the victim is not the same as invocation of the jurisdiction for the purpose of compounding an offence. While compounding an offence, the power of the court is governed by the provision of section 320 CRPC. The power to quash under section 42 is attracted even if the offence is non-compoundable. In forming an opinion whether a criminal proceeding or complaint should be quashed in exercise of the jurisdiction under section 482, the High Court must evaluate whether the end of justice would justify the exercise of the inherent power. While the inherent power of the court has a wide ambit and plenitude, it has to be exercised to secure the end of justice or to prevent an abuse of the process of any court. The decision as to whether a complaint or false information report should be quashed on the ground that the offender and the victim have settled and the dispute resolved ultimately in the fact and circumstances of each case, and no elaboration of principle can be formulated. In the exercise of the power under section 482 and while dealing with a plea that the dispute had been settled, the High Court must have due regard to the nature and gravity of the offence. Heinous and serious offense involve mental depravity or offences such as murder, rape, and dacoity cannot be appropriately be quashed though the victim and the family of the victim have settled. Such offences are truly speaking not private in nature but have a serious impact upon the society. The decision to continue with the trial in such cases is found on the overriding element of public interest in punishing person for serious offense. As distinguished from serious offense, there may be criminal cases which have then Lordship, this will not be. Then Lordship, kindly come to 16.6, Your Lordship. in Deepak, Your Lordship, this court has specifically observed that the offence under section 307 is not and the offence under section 307 is not a private dispute between the parties inter se, but is a crime against the society. Quashing the proceeding on the basis of the compromise is not permissible. Similar is the view taken by this court in the recent decision of this court in Kalyan Singh, Your Lordship, the case which has been referred, Your Lordship. So my humble and respectful submission, Your Lordship, in view of the injuries suffered, Your Lordship, from the abdomen, Your Lordship, which is a vital part of the life of an individual, Your Lordship, and the fact that a dangerous weapon is used, Your Lordship, to stab the victim, in my humble and respectful submission, this is not a fit case, Your Lordship, for Your Lordship to exercise a 482 power, Your Lordship. That's all.
So can I get your Gulab case? Just very quick rejoinder, my lord. Gulab case. My lord, what my learned senior...
Just a minute. And the fact, coupled with the fact, Your Lordship, that the trial is going on, charges have been framed, and the accused pleaded guilty, Your Lordship, and the informant has been lodged.
My lord. My lord, in the case of Gulab 2019 for SEC 268, my learned senior has referred to this matter, my lord. This is a matter where this is a matter 2019 for SEC 268.
Para
Para 5 and 6, my senior has referred to these two paras, my lord. This is a case where the mens rea, once the mens rea was made out, one of the assailant was a hardcore.
Yes.
And they have fired by a country-made pistol twice.
Yes.
I was just going through the facts of the case. It was fired twice. And there was a mens rea to kill. But fortunately, this man survived. And one of the assailant was a hardcore criminal. The judgment says so. And they were convicted. Paragraph 11 onwards, the prosecution side has not read the entire thing. Paragraph 11 onwards, if you read, my lord. It's not. Paragraph 11, if you read, my lord, that's only talk. Gulab.
Delhi High Court, you mean?
No, not Delhi High Court. The 2019.
So you are talking about this Kalyan Singh?
Kalyan Singh. No, not that one. 2019 for SEC. You refer to 2000.
Kalyan Singh, no?
That Gulab is 2019 5, I think.
268. Kalyan Singh, this is the one. Para 5 and 6.
Para 5 and 6.
Yes.
Oh, it's not. I'll just refer to this. Oh, I'll just take back, my lord. I just made a mistake there. I thought this is wrong citations, my lord. Anyway, my lord, very quick rejoinder, my lord. Very quick rejoinder to my learned senior, what he has stated, my lord. Facts and circumstances, my lord. Now, the mens rea, my lord. Whether this altercation happened because of a pre-planned or whether I wanted to stab my father-in-law, my lord.
So no mens rea.
There was no mens rea, my lord, and it happened in the fit of the moment because they threw my kitten to the bush, and that the FIR also has come in that way only. They have read out the FIR, my lord. Therefore, my lord, now the things have cooled down. They cooled down. They want to compromise, my lord, and there is no bar in exercising 482, my lord. So that is the quick rejoinder, my lord, I wanted to.
What about the other respondents?
Oh, Lordship, so far that contingent, Lordship, that is, in my humble and respectful submission, that is a matter of evidence, Your Lordship. It's a matter of evidence, Your Lordship. That will come out only during the court.
Yes. Who's for respondent? 3.
I'm appearing on behalf of respondent 3 and respondent 2. Your Lordship, I have it was simply a mistake, Your Lordship. I have no objections with regard to the question of the FIR. Since it is a family matter, Your Lordship, and the finding of the FIR is without any second thought, Your Lordship.
Yes. further parties, I'll pass the orders.
Obliged.
Item number 6.
That is fixed for appearance of the
Could not be filed today, and as such, some more time is prayed for the same to be filed. Accordingly, let the formalities be completed, and the matter will come up for hearing after 2 weeks.
Item number 7.
Wait, please, Your Lordship. Your Lordship, as per the last date, we were supposed to file our affidavit of confirmation of service. But Your Lordship, due to some technical error, we haven't been able to file the same. Your Lordship, we pray for 2 more weeks' time to file the same.
May please, Your Lordship. Lordship, as per the cause title, Lordship, the state of Meghalaya was a mere party, but then notice was given upon us.
Why?
It is not a party.
Yes, Lordship.
Then why have you given him notice?
Your Lordship, as per the procedure while filing, Your Lordship, they required the signature, that's why.
Signature who?
The state, Your Lordship, because it was a criminal matter.
Is it so?
There's been a practice in the registry that every petition which is filed under the nomenclature of a criminal petition, the registry insists that invariably, despite the nature of the dispute, a notice has to be effected upon the state.
No.
Then only the petition will be registered, my lord.
No, under what rules? High Court rules?
No,
Are there High Court rules to that
the
effect?
High Court rules do not say that.
Then?
Once it's a private dispute, my lord, it is a private dispute.
Yes.
But it is very difficult to reason with the registry, my lord. So,
No, you see, they must have done it under some rules or notification or.
my lord,
but then,
the best of my understanding, my lord, there are no such rules, my lord. It's a private dispute. It's a private dispute between 2 parties, my lord. In a criminal matter, no doubt, but the registry is insisting that unless notice is effected of the state, they will not register it. And likewise also,
I'll check it out.
If I may just point out, my lord. Now what happens is that now in cases where the parties reside outside the jurisdiction of the court, the normal practice is, as per the court's direction, my lord, notice is effected by way of registered post. Now, my lord, once it goes by way of a registered post, my lord, now we have the privilege of looking at it on the net. There is a tracking system, my lord. My lord, thereafter, like in this case also, my lord, we have tracked it. We found that as per the tracking report, the notice has already been served on the party. Now, my lord, thereafter we are required to file an affidavit. Now, my lord, in that case, normally earlier what we used to do as a matter of practice, the lawyer himself swears an affidavit that on such and such day steps were taken, and this is the confirmation report. Now, my lord, the registry is not allowing us to file that affidavit also, saying that there is a direction of this code that all affidavits have to be sworn by the concerned party. Now, my lord, that direction is in a different context. That direction, my lord, I am aware of it. That direction was passed by the former, initially it was passed by the former Chief Justice.
Is it, no, is the direction, in course of a proceeding?
In the course of a proceeding, my lord, in the course of a proceeding. So, my lord, there also the registry is insisting that such affidavits also have to be filed by have to be filed by the parties concerned. Now, these of course
See,
issues are.
if you wish to distinguish that order, you could have filed an application. You get a clarification.
Well, this of course has to be taken on the administrative side, my lord, so that it
Exactly.
is convenient for the parties also and convenient for the lawyers also.
But it's a judicial order, so
My lord.
a judicial order has to be passed,
My lord.
placing the matter before the Chief Justice on the administrative side.
My lord.
Otherwise, if you say that because of such order, the confusion has been created now. But as long as the order is subsisting, then we can't do anything.
That needs to be done, my lord.
So now what remains is then you have to abide by that order
My lord.
and file the affidavit of service through the petitioner himself.
My lord. My lord, 2 weeks time may be given, my lord. Will do.
When a counsel for the petitioner has submitted that the respondent, all the respondents,
All respondents, my lord.
that all the respondents have received notice. However, the affidavit of service could not be filed today, and as such, sometimes prayed for the same to be filed. As prayed for, allow this matter for 2 weeks.
All right.
Item number 8.
My lord, in this case, on the last occasion, this court mentioned the miscellaneous case.
Yes, that court's order and vis-a-vis the Supreme Court's order. So have you?
No, my lord, the query was that whether the present petitioner has been substituted.
Oh, that is the first.
It was already done. My lord, if you not supposed to see. 21.
Substitution in the main petition.
Substitution was done in the main as well as the miss case. This case. We also come to miss case number 21. On the same date, the main petition's substitution was done. In the cause title, my lord, on the first page itself.
Yes.
Substituted by court's order dated 17/3/2022. Pass in miss case CRP number 7 of 2022.
Okay. So now what remains?
What remains, my lord, for this case to be disposed of, I mean the miscellaneous application. Although I have said in the last occasion there was no necessity. Maintainability, my lord, as it is also, it's always open for any party to raise. But since the High Court, Supreme Court has made a specific, my lord, will see annexure 1, page 7.
Annexure 1
of this petition, miss case number 21 of 2018. Annexure 1, my lord, page 7.
Yes.
Page 7, para 2. The learned senior counsel further submits that the maintainability of the revision petition pending before the High Court may be directed to be heard as a preliminary issue. The petitioner may raise a preliminary issue before the High Court, in which case the High Court will decide the same before hearing the case on merits. So this was the order of the apex court. My lord will come to the next page, page 8, annexure 2. Heard Mr. So-and-so and counsel assisted by so-and-so as well as so-and-so. Mr. K. Paul and counsel submits that there is a direction that the court is to hear on the maintainability of the petition. However, he has not filed any proper application before this court till date. He is directed to file a proper application along with a copy of the Supreme Court order with advance copy to the learned counsels for the petitioner. My lord, list the matter after 2 weeks on maintainability of the petition and further orders. So even here, there was, first of all, the court directs me to file an application, then fix the date for hearing on the maintainability. What prompted us to file this present petition, my lord, is page 9, annexure 3. Heard Mr. So-and-so, learned counsel assisted by so-and-so, learned counsel. Application for maintainability has not been filed by the respondents. Hence, application for maintainability is hereby closed. Respondents' counsels are present. List this matter after a week for hearing. So, because of this order, my lord, we have filed this miss case. But unfortunately, it was never.
You see, against this order, you come by. Have
No,
you come?
just for a recall this order to allow us to file the application. But my submission is that, my lord, there is no requirement for filing of any application. Because question of maintainability is.
The Supreme Court has directed. What
Yes.
else do you need?
Yes.
What else do you need? But then.
Since there is an order, so for abundant caution,
That's okay.
yes, we had filed this application.
But recall of the order means review of the same.
Yes.
Lord, what I pray, my lord. Apparently, this order cannot sustain, my lord.
Yeah.
So, my lord, what I pray that because to go into maintainability, we need to highlight the facts of the case also.
Yes.
My lord.
Yes,
Even the merits will have to be.
That of course.
So, my lord, if this order is recalled and the entire matter we heard, including maintainability, no need for filing any
No need
application
of
for that.
filing.
No, there's no need to file. See, the Supreme Court order says so. Since that direction is there, that the issue of maintainability is to be heard first. So that will be heard.
Even in the absence of the Supreme Court order also.
Even so,
But
these are matter of course.
Yes.
Matters of practice. Petition is not maintainable. It's not
But the thing, like I said, this has complicated the issue.
Yes, unnecessary. I mean, this may be closed.
Where is your application in this regard and in respect to this order?
This is the application. No? This is Miss Case number 21 of 2018.
No, here.
Yes, yes.
Okay.
Because by this application, at page 4, we have said that it is most humbly prayed that the Lordships may be pleased to admit this petition because issue upon notice upon the respondents to show cause as to why the order dated 4/10/2018 passed by this Honourable Court be not recalled, and on causes of causes being shown, and upon hearing the parties be pleased to recall the order dated 4/10/2018, and be further pleased to allow the applicant to raise the preliminary issue on maintainability and to file an application on the issue of maintainability of CRP number 21 of 2016 for the ends of justice.
Learner counsel for the parties. This application filed in this case is for recall of an order passed by this court dated 4/10/2018, whereby the application for maintainability, which was apparently not filed on direction by this court, has been closed. However, looking at the larger picture, the council have led this court to the order passed by the Honourable Supreme Court in SLP number, who is the
28975.
975 of 2016.
SLP number 28975 of 2017
16
of 2016 of between the parties herein, wherein by order dated, where is the order dated? 39/2016. The Honourable Supreme Court inter alia has directed this court to hear the parties firstly on the issue of maintainability as a preliminary issue. This being the case, it would be incumbent upon this court to abide by the superior court order, and as such, notwithstanding the fact that the order dated 4/10/2018 being passed in this regard, it would not be required for the parties to have filed a specific application seeking prayer for hearing on maintainability. Accordingly, the said order dated 4/10/2018 is hereby recalled. On being directed by the relevant order of the Honourable Supreme Court, I know Shavato, this petition is accordingly disposed of.
Also, Miss Case number 22. Same. Yes. Because there are two matters linked.
Number 22 is the same order.
CRP number 28, where I appear.
We'll just let me pass.
This is the Miss Case.
This is a Miss Case.
Yes, Miss Case 21.
Miss Case
and 22.
disposed of.
22 also.
So now we go to the main case.
No, not Miss Case number 22 also is there.
Yes, so you said same order, isn't it?
Yes,
Same order in this case.
So same order. Now, pick the main case. No? Main case is this 28.
28, madam.
In view of the order dated 30/9/2016 passed by the Honorable Supreme Court in SLP number 28975 of 2016, parties are called upon to be heard on the issue of maintainability.
My lord, if I may pray, let them file an application as to why it is not maintainable, my lord.
The court has already said in the.
No, the issue of maintainability has to be heard.
My lord.
So,
of course,
then it will be heard.
What I like to submit here is, my lord. My lord, this is this case, my lord, has a long checkered history, my lord. The issue of maintainability cannot be gone into without going into the merits of the case.
No, exactly, Mr. Gautam. The point is, even if you hear on the issue of maintainability, the court will still have to rely on the background facts and circumstances.
My lord, will have to go into the backgrounds of the background of the.
So that will be, in course of hearing, it will be taken.
Yes, I fairly concede to that.
Because they may be relevant, it may not be, or we may look into the procedural aspect of the matter. So all those things have to be considered. So
When
we'll
we look at the procedural aspect of the matter, my lord, then also, my lord, the history, the checkered history
Exactly.
of the case is such that the facts have to be gone into, my lord.
Okay, you can cite relevant authorities on that.
But one aspect remains, my lord. Maintainability can be on various grounds, my lord.
Yes.
So we do not know on what ground they'll raise the issue.
It can be on law and facts also. Anyway, let it be heard, the man.
Let it be heard. Because Supreme Court has not, given a detailed order as to what portion or what part to be heard as far as maintainability is concerned. It implies that everything has to be heard.
Whether it is time barred or whether it is for non-joinder of parties or because of some jurisdiction. So we
It's a
don't
mixed question.
what question they'll raise, my lord. We will answer accordingly.
So therefore, my lord, in all fairness, I was submitting, my lord, not to be taken by surprise. If learned senior counsel files a petition as to why these petitions are not maintainable, then my lord, we will be in a better position to.
The petition was filed by you.
My lord.
No, this petition was filed by you. This revision was filed by you.
No, my lord, in fact,
We are
to assist this court, perhaps.
We are looking at the maintainability of this petition, this revision.
Our petitions, my lord.
So now you have to, you have to put forth your grounds as to why this petition is maintainable, and they will object to that.
My lord, rightly or wrongly, the petitions have been admitted, my lord. Now it is for my learned senior friend to say why it is not maintainable, my lord. Then only we will.
We will do that. If it's required, written submissions also will be submitted before this court. But if this court desires, to appreciate this case, which, as my friend said, is a little twisted, I can be allowed to file an affidavit. Also, all this 227, I may be allowed to file an affidavit, a short affidavit,
on the issue
to bring on records, because some of the orders which have been passed by the trial court also have not been annexed along with this petition. Although the records have been called for, that's a different issue. It is just to assist the court. Before the next date, I'll file a short affidavit, including the question of maintenance.
In view of the main case, as submitted by Mr. T.T. Dindo, learned senior counsel, appearing on behalf of the respondent. An affidavit or relevant petition, if so instructed, may be filed to assist the court in appreciating the issue involved herein.
In both the cases.
Good.
Thank you.
Okay.
Item number 12.
Item 12, I have some difficulty today, Mala. It is taken up after next week. Then next Monday. Next Monday. No, next week till Wednesday I will not be able to. I will not be free.
Take it on
Thereafter, week thereafter.
2016 matter. So.
2016 matter. 2016 matter, my lord. So it should be.
But be sure, you see, if, Mr. Bhattacharya, as and when it is taken up next time, be sure to,
My lord.
please make it a point that this
Any
matter can be
appropriate
heard.
date, it is better according to your convenience. Lord, it may come up on the, otherwise it can come up on 23rd or 26th.
Not on Friday, 26 then.
26 will.
On pre-made by the parties, this is matter on 26.
Item number 13.
This is a very short matter, my lord. This is a case of termination of a teacher, my lord. And our case is that Section 9, my lord, of the Act requires that there should be prior approval, my lord. The lordships have dealt with a similar matter.
Education code.
Education code, my lord. Though the other facts are there, but the matter, in my humble submission, can be disposed of only on that ground, my lord. And because there is no prior approval from the government, the termination is illegal, my lord, and he has to be reinstated.
Okay. You've been terminated. So, please state your facts.
This is, Your Lordship, I think this is with regard to the salary, not for termination. Not with regard to the termination, this is with regard to the payment of salary, Your Lordship.
Prayer.
Let us look at the prayer.
For cautionary studies of the dismissal order.
You saying salary, Mr. Abraham? What is this?
Yeah, this actually what happened, the allegation is that the principal.
So look at the prayer.
Page 13, my lord.
But the fact of the.
See, this is to quash and set aside the dismissal order. And what else?
Let him, sir. I'll reply accordingly, Your Lordship.
My lord, what my senior, my lord, if I may submit, there are 7 matters has been tagged along, my lord. So if the other five matters, my lord, it is on the context of release of salary. So basically, deciding number 1, there is an issue of termination order. In the other 5, there is a prayer for release of salary. And on the last.
And what about the other 5? They don't involve termination.
There is no prayer as such.
No, there is no termination. Have they been terminated or not?
There is an order of inspection which is the private respondent is affected, not the petitioner.
What happened in this case, I'm appearing for the school, raising the case. Now, the WPC number, first to the WPC numbers 468 and 469.
Yes.
They were terminated from service application. This issue. WPC number, my lord, 470, 471, 479. They were also terminated because they were teaching in the Assam schools. And they produced while getting so they were terminated. And the last two WPC number 480 and 481. In fact, they are they're not following the sanction teacher. Their expenses are paid by the managing committee only. They never come to school. So managing committee then even if they come, we welcome them to come. We welcome them.
But voluntarily they have not come.
Voluntarily they are not coming to school. So these are the cases. Another case.
No, but in that event you have terminated them.
There is no termination.
No termination.
They are not coming to school.
It was a downgradation. In my case, there's a downgradation. There's no termination as such.
My lord, they're totally confusing the facts, my lord. If I may place the case.
Yeah, let him place it.
7 cases are different, my lord. So we are on item number 1.
Appears to be.
Maybe it's connected to the same school, my lord, but the facts are different, prayers are different in every case, my lord. So item number 1 and first and second item more or less are similar, my lord. Both are cases of termination of service without prior approval of the government, my lord, as required under section 9 of that, my lord. The rest of the matters today only at first and second items taken up, my lord.
Yes, I think we should do that.
Ready?
How long will it take?
Take some time.
So we'll come back after lunch.
Yes.
This is 13 to
13 to 19.
19.
So 13 and 14 can be disposed of today, my lord. Other matters will be.
26 to 28 is a technical.
26.
26 to 28.
Same.
Well, this criminal case, but the basis of allegation is derived from the litigant. Same allegation.
There is an inspection in which my was found there was misappropriation of money by the private respondent in this petition. So challenging that my not before the local, those orders have been challenged in number 26, 27, and 28.
That is the same allegation in the litigation.
Okay. So this 26 to 28 we will hear it on another date.
I'm for the state. In those criminal petition, I'm for the
So we'll
state.
take up the matter in another date then, because I think the other.
Yes, Your Lordship. On that day, in fact, I made a submission, Your Lordship, how they are, these criminal petition are linked to the writ petition.
Misappropriation connecting to that writ petition.
We'll not confuse the issue. We will hear the matter, on the specific, facts and circumstances of every case.
While hearing my lord, this writ petition, the criminal petition, the pleadings or the materials of the petition may have appeared.
That is
a different.
That's a different issue.
Lordship, then in my humble and respectful submission, let these 3 criminal petition be heard, Your Lordship, after the disposal of all this writ petition, Your Lordship.
There is an urgency involved in the criminal petition. Prosecution is going on against you. That is it. In the criminal writ petition, my lord, other side is returning one after another for many years. Because I goes back together with my prayer last occasion. Very urgent.
No, we never pray for adjournment.
This is the disposal, my lord. Consider the remaining criminal petition. I may not take long. Everything is there.
Lordship,
So what we have to do is we have to first concentrate on the
writ petition, Your Lordship.
Yes. My prayer is that Lordship remain take together, my lord. That will serve the purpose. Otherwise, if Lordship segregate and come back, that would be a problem.
Fine. What we can do, fix the matter on the same date. Not necessarily they should be tagged together. What else do we have left? This 25?
25, Your Lordship, then we'll. 25, Lord. We'll take it on after 2 weeks. Some other day, Your Lordship, 25.
On pay made by the parties. This is matter after 2 weeks.
Lordship.
Item 29 was also there, my lord.
Yes.
Item 29 is only, my lord, it should be reserved for judgment, my lord. This is
Why is it? Is it for filing of a written
on
argument?
the last occasion, my lord, the other side had prayed that they'll file it on the course of the day. That's why a date was fixed. So it has been since filed, my lord.
29th. Parties have filed their written argument. Therefore, the matter is now reserved for judgment.
Highly obliged.
So we meet at 2?
2:15.
2:15.
Second call, item number 13.
Before the case starts, so only the first two petitions are connected. Entire petitions are connected. Single level of allegations are there. So it required to be taken up together.
The whole on.
Yes. Therefore, it was filed together. Everything was actually at the same time, list together, and together.
I don't. Can a common judgment be passed on? That's my question I'm putting. To in my humble submission, a common judgment cannot be passed.
Yes, maybe, yeah. But you said that there are, I mean,
Separate matters.
two matters are similar. Facts, issue is similar. The other are not.
But what the grievance of my friend is that termination is illegal. Apart from challenging termination, there was an allegation against me in the state respondent that there was misappropriation of funds by all of us. That allegation is contained in all the petitions.
Misappropriation of fund, that is a salary meant for them.
Meant for them. That is the allegations. Though the audit has given all the evidence.
Okay. Is that also in your pleadings?
Yes, in all the petitions.
I don't know. My relief is only my reinstatement, my lord.
Reinstatement.
And pay my salary, whatever has not been paid.
The problem here now, the FIR is lodged, a criminal prosecution is going on against me with regard to misappropriation. My friend it seems doesn't want to press the second point. In my grievance system, my lord, writ petition was filed. It was lifted, entire complaint was lifted from the writ petitions, moved to Lokayukta, got the direction from the Lokayukta, and registered a case. And the case is going on. Let my friend start my question.
Yes, please.
Lordship, this matter pertains to Garo Dubi Higher Secondary School, my lord, in Garo Hills. The school was set up in the year 1994, and the petitioner is one of the founder teachers, my lord. He is appointed since the time of inception of the school itself.
Yes.
1994, he is serving in the school, my lord.
Then a Dubi.
Garo Dubi, my lord.
Garo Dubi. Okay. Since
1994. Since the time of inception of the school itself, my lord. After he served for about 20 years, my lord, 2013-14 problems started, my lord. The respondent number 4, who is the principal and secretary of the school, what he started doing, my lord, he'll draw the salary as usual, my lord, all the schools, and not pay to the teachers, my lord. And sometime not pay the entire amount. That time salary was 10,000 rupees, my lord. So what he'll do, he'll say that now there are school expenses, so deduct from the salary of the teachers only. So sometimes he used to pay 7,000, sometimes 8,000, and then after 4 months he'll pay salary only for 2 months instead of paying for 4 months. And for himself, what he was doing, my lord, he was drawing double salary from the higher secondary section also and from secondary section also, my lord. That is on record, my lord. I'll point that out. So, and the teachers surviving on the salary, my lord, they had no choice but to approach the authorities, my lord. This is what is happening, going on in the school. So they wrote a complaint, my lord. My lord, lordships will see the complaint at page 17, my lord.
Yes.
This is there are several people, my lord. Number 1 is a writ petitioner, my lord.
Yes.
Well, only one important fact, my lord. Subsequently, the petitioner was appointed as vice principal, my lord, of the school. Though he joined as assistant teacher in 1994, subsequently he was promoted. He is supposed to be vice principal of the school, my lord. The complaint is addressed to the district school education officer, my lord, West Garo Hills. This is dated 7th April 2017. The complaint basically, if I may just point out, my lord, With reference to the subject noted above, we, the undersigned assistant teachers and assistant lecturers of Garo 2B Higher Secondary School, have the honor and humble submission to report you that the hereunder in favor of your kind information needful action. That, sir, it is been our painful duty to report you that in the year 2016, the respected principals cum secretary of Garo 2B Higher Secondary School is devoid of any reasons thereof, has stopped our salary for 2 months out of 4 months, that is September, October, November and December 2016. That, sir, on several occasions we have politely approached the principal cum secretary of Garo 2B so and so in the matter to release our salary, but unfortunately till today such approaches yet to yield any positive response. That, sir, till today we don't have salary fixation. We are getting minimum salaries, and by which we are somehow arranging daily 2 square meal for our children. And if such minimum portion of salary stand irregular and sometimes not disbursed, how we will survive? That, sir, it is learned from the reliable sources that the sanction for staff salaries of Garo 2B Higher Secondary School have been under withheld. So we have made up my mind to knock your door for proper address of our issues at possible earliest. So, well, this first complaint was submitted on 7th April 2017, and next page is a reminder, my lord, because there was no action for 2 weeks. They submitted another one to district school, page 18, my lord. But around this time, my lord, around 2016, the salary which was 10,000 fixed earlier, my lord, that has been increased to 20,000 per teacher, my lord. Then what happens, my lord? Page 20, my lord, so kindly turns. Because of this complaint, my lord, the district school education officer dissolved the managing committee, my lord.
Yes.
If I read, my lord, the order. The school managing committee of Garo 2B Secondary and Higher Secondary School is hereby dissolved due to financial misappropriation of sanctioned money meant for salary of the teachers and mismanagement. The management of the school will remain under the control of the undersigned with immediate effect. So the managing committee was dissolved. Administration was taken over by the DSEO, my lord. In the meantime, my lord, next page, Annexure 6, my lord, is another complaint by, not by us, my lord. This one, Rasidur Rahman, he submitted a complaint to Director of School Education.
Who is he?
He must be some parent of some of the student, my lord. But it's not by us, my lord. It's not by the petitioner, my lord.
Yes.
Page 23, lords will see.
Yes.
This is a letter from Director of School Education to District School Education Officer. Page 23.
Yes.
So Director writes to DSEO, my lord, complaint against the Principal Secretary, Garo 2B Higher Secondary School. With reference to the subject cited above, I am forwarding here with a copy of the letter addressed to Sri Asahel D. Shira, Honorable Parliamentary Secretary and local MLA, along with the copy of the letter from Rasidur Rahman, referring to the previous letter, my lord, regarding complaint against the Principal cum Secretary, Garo 2B Higher Secondary School. In this connection, you are requested to inspect the school immediately and to submit a detailed report to this office of the undersigned at the earliest for further necessary action.
Yes.
Next page, my lord. Acting on this complaint, my lord, the Deputy Commissioner West Garo Hills, page 24, my lord. This is order dated 20th June 2017. Number so and so. Sri P.R. Sangma, MCS, Block Development Officer, Salsela CNRD Block, and Extra Assistant Commissioner is hereby deputed to cause inquiry with Inspection Committee, along with police team of Rajawala Outpost regarding Garo 2B Higher Secondary School anomalies. The Inspection Committee shall comprise of the following officers. So they're all, most of them are government officers, my lord. Additional Director of School, Joint Director, District School Education Officer, Subdivisional, and one Teachers Association representative, my lord. And the inspection committee shall conduct inquiry on so and so date and meet at Rajawala Police Outpost and so and so forth. This the inquiry report comes, my lord, from this inquiry committee, which was headed by the executive magistrate, my lord. And this is very interesting, my lord, the report, my lord. But it's a 2.5 page. Lordship permits me to read the entire thing, my lord. There are many things in this, my lord.
Okay. Yes.
Inquiry report of the inspection committee regarding anomalies of Garudu Bihar Secondary School. Members of the inspection committee for inquiry along with police team of Rajapal outpost reached at 9:50 a.m. at Garudu Bihar HS school to conduct inquiry and found the following anomalies.
Yes, please read.
Number one, the half-yearly examination was going on. Altogether, there were 11 students appearing the examination. Out of 11 students, 6 were from class 9 and 5 were from class 8. As per schedule of the half-yearly examination 2017 of Garudu Higher Secondary School, students class 6 and class 8, class 7 was supposed to be appear in the examination, but none of them were present. As per routine, students in class 10 examination is not there, but it seems no student in class 10 since there is no routine. It is doubtful of presence of students of those classes. The principal of the school, Sri Islam Haq Chaudhary, the respondent number 4, my lord, was absent at the time of inspection, and in the school, when we asked some of the teacher staff, they informed that he, bracket principal, was absent since last few weeks, whereas no information was received by the office of the DSEO about his leave application and station leave for his long absence from the school. When the inquiry committee entered in the teachers' staff room and checked teachers' attendance register, we found that 6 teachers' staff name and all were present, and 2 of them in examination duty. In the same room, Vice Principal Sri So-and-so, who is a writ petitioner, my lord, here, was present. He informed that one outsider, Mr. Abu Hanif Chaudhary, who is the younger brother of the principal, is sitting in his chair claiming as Vice Principal of the school, my lord. There's a drama happening in the school, my lord. Somebody else is sitting in my chair, my lord. Then the inspection committee entered to the vice principal's room, where we found Mr. Hanif Chaudhary, principal's brother, is there. When additional director of school education and literature asked him about his identity, he introduced him as vice principal of the school. Later, he has shown a copy of the letter which is doubtful, and at the same time he is running another school, Al Amin Madrasa Higher Secondary School, Garodobi, nearby. As per office record of DSEO, resolution approval of reinstatement of Sri Abu Hanif Chaudhary as vice principal is not available as claimed by him. His name is not appear in the pay statement of the staff. Hence, his identity as vice principal is not known by the department. He later started shouting to us. Magistrate on duty requested him not to shout, instead to cooperate with the committee members for the entire process of inquiry. Some of the staffs were busy for video recording from Android mobile phone. While one of the inspection committee member asked one of the Android phone video recorder about his identity, he introduced himself as Abu Bakar Chaudhary, who is son of the principal, working as assistant librarian of the school. Committee members inquired about library and stock register of books, but nothing is available in the records. There is no post of librarian in any government school of Meghalaya. Hence, committee members could not ascertain from where he is drawing salary as an assistant librarian in a government-aided school. While asked about identity of another Android mobile video recorder, he introduced him as Salim Chaudhary, closely related to the principal, as the LD of the school. We asked him to show the acquittance register of teachers' payment, students register of HS section, produce book purchase register, etc. The LDA informed these are not available and all have been taken by the principal at Shillong. He says that all the registers and records were with the principal and he took away with him to Shillong, for which the reason is not known. When we asked an appointment copy of their bank account number from teacher and assistant lecturer, some of them were very cooperative and submitted copies of those, which has to be compared and checked from our office record. It is found there are 2 assistant lecturers in political science, where there is no class 12 students, whereas government higher secondary schools where more than 200 students studying have only 1 assistant lecturer in each subject. One of the assistant lecturer informed that he appointed as a political science assistant lecturer, but principal is asking him to bring certificate of philosophy MA, so he feels insecure in service as principal collected MA in political science. Upon further inquiry, committee found that the principal Sri So-and-so Chaudhary was drawing double salary, that is, first as principal from secondary and as assistant lecturer for political science from the senior secondary section at the rate of rupees 20,000 and rupees 20,000 respectively. Inquiry team also found that one Samiul Islam, assistant lecturer for education, is a ghost teacher He never attended his duty and none of his staff had seen him. As per the payment statement, salary for Saminul Islam is drawing regularly, but money whom to pay nobody known. It is also found that most of the members of the school managing committee are close relatives of the principal. It is thus malafide intention to include all his relatives in the committee so that he can do according to his whims and fancies. Garudubi Higher Secondary School is located within a radial distance of about 1 kilometer from reputed HN Higher Secondary School. Parents are sending their children at HNHS school because of good result and qualified staff. The habitation population surrounding of Garudubi HS school is very thinly populated. Parents of the students are not happy as a result of so and so is nil every year. So villagers sending their children to HNHS school. Moreover, principal behavior is dictatorship style, remains busy with high court cases, RTI in others' name. Teachers are not happy with the principal as salary is not paid timely and less payment and threaten the teachers for termination. So the recommendation, my lord. In view of the above findings, the committee would like to suggest the following points for the interest of the student, teacher and general public of Garudubi and surrounding villages. Sri Islam Haq Chaudhary, Principal, Garudubi Higher Secondary School, should be degraded to assistant teacher of secondary section. Vice Principal Sri Mokbul Hussain, that is the principal, that is the petitioner, my lord, may be promoted as principal of the Garudubi Higher Secondary School. Salary of genuine teaching staff should be paid through the bank account from the office of the DSEO as per the government sanction until new school managing committee is formed. Principal Sri Islam Mukta should be refunded his misappropriated amount for he had drawn double salary and the salary drawn in the name of Sri Samuel Islam, a ghost teacher. School managing committee should be constituted as per guideline given by the department and general meeting will be called as per direction from DSEO and during the general meeting video recording will be done and general public guardian parents will be called in the general meeting. So my lord, lots we seen the inquiry is quite damaging for him, my lord. Now when the inquiry report was placed before the deputy commissioner, my lord, page 29 is the order passed by the deputy commissioner.
Page 29.
29.
Yes.
It says, my lord, in pursuance of the report submitted by the inspection committee pertaining to anomalies of Garudubi Higher Secondary School, West Garo Hills, that the following points have been passed. So the same 5 points have been noted down here, my lord. And then DC, henceforth the district school education officer Tura is hereby directed to initiate action as per points indicated for smooth functioning of the said schools. So 5 points were recommended by the inquiry committee, my lord, at page 27, and DC has accepted all 5 recommendations. Basically to downgrade the principal, my lord, to upgrade me as a principal, to recover the double salary taken by him, and also to recover the salary paid to the ghost teacher. That is 4th, and 5th is reconstitute the managing committee after following the rules, giving wide publicity to the thing, my lord. So, my lord, this DC's order was, because 5 things were directed by the DC, my lord. So, one by one, all 5s were complied with, my lord. The government took action. So cause notice was issued, my lord, at page 30 to the principal. Page 30 and 31.
32.
30 and 31, my lord. Page 30 first, my lord.
Yes.
This is from Under Secretary, Government of Meghalaya Education Department to Director of School Education. In inviting a reference to your later quoted above, I am directed to request you to kindly issue so cause notice to the Principal, Garo Higher Secondary School, and afford an opportunity to explain why action as proposed should not be taken against him. So action is basically on 2 counts, my lord, to recover the double salary and to recover this ghost teacher's salary from him. Next page is also in the similar line. This comes from Director to DSEO to issue so cause notice to Principal. And pursuant to that, page 32, my lord, so cause notice was issued to him.
Yes.
This is from DSEO, my lord.
Yes.
But only one thing I want to point out, my lord. The DSEO at that point of time, my lord, was Mr. S.K. Saha, lots of seen on the top from.
Yes.
Mr. Sri S.K. Saha, MA Maths and so. and 2 Islam Haq Chaudhary, the principal. So-cause notice, you are hereby asked to explain why action will not be taken against you for misappropriation of government grant which has been sanctioned and released for payment of salary for the assistant teacher and assistant lecturers of Garudu Higher Secondary School. Misappropriated amount which have been drawn as double salary as assistant lecturer, as principal of a school, and in the name of Sri Samiul Islam, a ghost teacher, you have drawn 20,000 plus 20,000 plus 24,000 is equal to rupees 58,000 only per month, remaining absent in the school for more than 5 months without any information to the undersigned as per record of the attendance register issued by the undersigned.
Yes.
By next page, my lord, the one of the recommendation, my lord, of
No, after the show cause, what happened? Proceedings started?
No, my lord, that things changed, my lord. I'll come to that, my lord.
Okay.
Because the moment DSEO changed, my lord, because Mr. Saha retired soon thereafter, and the entire story took a complete U-turn, my lord.
Yes.
Page 33, my lord. This is the order by DSEO, my lord.
Yes.
It says, in pursuance of the order number so-and-so, dated 22nd August 2017, from the Deputy Commissioner, Sri Islam Haq Chaudhary, Principal of Garudubi Higher Secondary School, is hereby degraded to Assistant Teacher, and Sri Mokbul Hussain, who is the Principal, my lord, Vice Principal, is promoted to the post of Principal of Garudubi Higher Secondary School in place of Islam Haq Chaudhary, degraded with immediate effect. So, my lord, first direction or recommendation, there is so-cause notice to him. Second was to downgrade and upgrade. That has been done, my lord. The next page is that salary should be paid directly by the bank transfer, my lord, from the government of, from DSEO office. Page 34 and 35 will indicate, my lord. Page 34, my lord.
34 is
the payment of salary directly by the by the DSEO directly to the bank account of the teachers, my lord.
Yes.
Because that was one of the recommendations, that salary should be paid directly, my lord. But here, lordship will kindly see one very important aspect, my lord. In the first table, serial number 1, my lord, I.H. Chaudhary, teacher. He is the principal, my lord.
Okay.
So he is there in the first list also, and he is there at serial number 1 in the second list also, my lord. Of course, now he is, because everything has been discovered, so he was not paid nil, my lord. But this indicates that he is there in both posts, my lord.
Okay.
Page 35 is for subsequent months, my lord. Same thing here also. The salary was paid by the.
Yes.
Normal page 36 is one of the direction was to constitute fresh managing committee by calling a public meeting of the parents and other things, my lord. Page 36 is a letter from DSEO, my lord.
Yes.
To the petitioner, my lord. Here, lordship will kindly note to Sri Mokbul Hussain, who is the writ petitioner here, my lord. Principal Garudubi Higher Secondary School.
Page
36.
Okay.
I was pointing out, my lord, two.
Yes.
Mokbul Hussain is the writ petitioner before lordship, my lord. And he is addressed as Principal Garudubi.
Okay. Please.
So this says, my lord, with reference to the subject cited above, the undersigned is hereby directed you to convene the general public meeting to constitute the new school managing committee at the earliest for smooth functioning of the school.
Yes.
And the next page is from Deputy Commissioner to Superintendent of Police, my lord. This is to provide police protection, my lord, at the time, in the school at the time for holding the meeting, my lord. It says, my lord, in view of the above, you are kindly requested to depute police personnel at the venue on 4th January 2018 at 10 a.m. for peaceful conduct of the said meeting. Copy of letter received from Principal Garudubi so-and-so may be seen enclosed. So meeting was convened on 4th January and DC asked for this thing, my lord, police protection.
Okay.
So till here everything is in one direction, my lord.
Yes.
Around this time, my lord, Mr. Saha was the SDSU all this time. He retired from the post, my lord.
Okay. So he retired somewhere in January, or sometime in
January or February, my lord. My lord, in para 19, I have made a statement, my lord, because para 19 and 20 of the writ petition, my lord. I just read para 19 and 20. That the petitioner states that the respondent number 3, white letter dated 22/12/17, directed the petitioner to convene general meeting on 4/1/2018 for constitution of regular school managing committee in compliance of the recommendations suggestion of the inspection inquiry committee. The deputy commissioner West Garhills Tura, white letter dated 28/12/17, informed the superintendent of police West Garhills Tura about the general public meeting and requested him to depute police personnel on 4/1/2018 at the venue of the meeting for peaceful conduct of the meeting. However, school managing committee could not be constituted due to the unwarranted and unjustified interference by Sri B.G. Mumin, the joint director of school education and literacy, Tura. So, my lord, on 4th January, meeting could not be held. Managing committee could not be constituted, my lord. Then para 20, my lord, that the petitioner states that in the meantime, the district school education officer Tura Sri S.K. Saha retired sometime in the month of February 2018.
Yes.
And Sri B.G. Momin took over the charge as in charge district school education officer Tura. So now what happens, my lord? If lordship kindly turns to the next page, my lord, page 38, my lord.
Yes.
Page 38, my lord. Now this is, by this time, B.G. Momin is the DSEO.
DSEO.
He takes a complete U-turn, my lord, the entire sequence of events. What he does, my lord, he reinstates respondent number 4 as the principal and downgrades me again. In pursuance of letter number so-and-so dated Tura so-and-so, Sri Islam Haq Chaudhary, the principal of Garo Dubi Higher Secondary School, West Garo Hills, who was degraded to the assistant teacher, is hereby reinstated to his original post as the principal of Garo Dubi Higher Secondary School, West Garo Hills, as per letter number so-and-so dated 6 March 2018 from Director of School Education and Literacy, Meghalaya, Shillong. The reinstatement of Sri Islam Haq Chaudhary, the principal of Garo Dubi HS School, is done by the undersigned after proper examination of the official records and found that the district school education Garo Hills Tura did not follow an official procedure such as so-called notice, an opportunity to place his grievance before degradation of the person concerned. The letter number so-and-so dated 8 September 2017, the degradation of Sri Islam Haq Chaudhary from the principal to assistant teacher and Sri Mokbul Hussain SK promoted to the post of principal of Garo Dubi so-and-so is hereby treated as cancelled with immediate effect.
So this was done at the level of this DSEO?
This was done at the level of DSEO, and
is he competent to do it?
My lord, that is the question, my lord. When so-cause notice has been issued to him, my lord, and on the recommendation of the inquiry committee, he was downgraded. So-cause notice has been issued to him, and I have been promoted as principal, my lord. He comes and undoes everything, my lord. Now, your lordship will see next page, my lord. Can't read also this one. By page 39, my lord, the same DSEO, my lord, he revives the managing committee also. The previous managing committee that was dissolved, I pointed out earlier, my lord.
Yes. Page
39.
39 is the type copy.
Type copy is not there. I'll provide type copy. This is little unclear, my lord.
39A is what? 39 is the type copy.
39A.
It is here.
My copy is not there.
If you can read it, then read.
It's little. You just read it. Well, my friend, I can't see this.
Pursuant to the letter dated so and so, 15 March 2018, and after through examination of all the norms in respect of Garudubi Higher Secondary School, so and so, no justification to dissolve the managing committee constituted irregularity without the valid proof of documents. In this regard,
What is this you're reading, Mr. Sheikh?
this is 39.
In this regard or in this connection?
In this connection.
In this connection, the Constitution of the School Managing Committee of Garudubi Higher Secondary School by letter dated so and so dissolved by the District School Education Officer is hereby reinstated and allowed to continue till term.
Full term.
Full term.
Till term.
The letter number.
In full term.
Full term.
I can read you. Yes.
The letter number so and so 15 May 2017 dissolved the School Managing Committee of Garudubi Higher Secondary School is treated as cancelled.
Yes.
By this letter, the Managing Committee, which was dissolved earlier.
So, my 5 recommendation DC's order. So, whatever was done pursuant to that, he's one by one he is undoing, my lord.
Yes. So this managing committee was revived.
Revived, my lord. Now he starts action against me, my lord. Page 40, my lord. He issues a so-called notice to me. Principal, after he comes back in power, my lord. My lord, I'll just take your lordship to the relevant part, my lord. Page 41 of the next page, my lord. This is the so-called notice, my lord, issued to me.
Yes.
To so cause why disciplinary action should not be taken against me.
Yes.
So, my lord, at serial number 4, my lord, at page 41.
Yes.
At serial number 4, para 4, my lord, he says, why had you made some bogus and fabricated complaint white number nil dated 7/4/17 and 21/4/17? He is referring to those first letters, my lord, when we complained that we are not getting salary, my lord. The page annexure 3 of the writ petition. So, what he is writing, my lord, why had you made some bogus and fabricated complaint white number so and so 7/4/17 and 21/4/17 addressed to the DACO, and the complaint dated 22/4/17 to Sri Asahel Sira, a politician. Now, Lord, you'll see the second complaint is not written, was not written by us, by me, my lord. A politician who is not the appropriate authority of the school against the undersigned and managing committee of the school, which are very much detrimental in the interest of the school. Prove the allegations framed by you in your above mentioned complaint in black and white. Then, my lord, para 5. Explain how did you acted as principal of Garudubi Higher Secondary School with effect from 8/9/17 to 7/3/17. My lord, I was on the order of the government, my lord. I was promoted. Now he is asking how did I act. So, my lord, all these fabricated complaint, my lord, he issues a so-called notice to me. Basically, a revengeful action, my lord. And then page 43, I am placed under suspension, my lord. After issuing so-called notice, he places me under suspension.
Yes.
As per the decision of the school managing committee of Garudubi so-and-so, by MC meetings resolution number 1 dated 7/4/18, which is duly approved by the district school education officer Garuil Sura, by his office memorandum number dated 10th April 18, Sri Mokbul Hussain SK, assistant teacher of Garudubi so-and-so, is hereby placed under suspension from his service with immediate effect until further order. My lord, next page, Lords will see page 44, my lord. As I submitted in the beginning, my lord, the actions were initiated against me and many other teachers, my lord.
Okay.
So against this suspension, my lord, we filed an appeal before the director. And in the appeal, the director says, my lord, because lordship will see in the first page serial number 1234 at the top itself, my lord.
Yes.
Sofikul Islam, assistant teacher English, terminated. Abdul Matin account, terminated. Abdul Basit Sarkar, suspended. And myself, number 4, my lord, Mokbul Hossain Sheikh, vice principal, suspended. So all 4 of us, we filed appeal. And what director said, my lord, lordship will see at page 45, the last paragraph, my lord.
Yes.
With regard to the suspension order in respect of Sri Abdul Basit Sarkar and Sri Mokbul Hossain, I am Mokbul Hossain, my lord. The district school education officer shall initiate and issue directions to the principal and the school managing committee to expedite disciplinary proceedings as per rules. Last paragraph, my lord.
Yes, yes.
And the teachers under suspension should be given subsistence allowance during the suspension period.
See, this is a counter order given against the principal or against the petitioner.
My lord, when we were placed under suspension, my lord, we filed an appeal before the director,
Yes.
to the higher authority. So what director said that directed the school to expedite the disciplinary proceeding, the so-called notice, whatever has been issued to me, and for the suspension period, please pay subsistence allowance to me, my lord. Now, my lord, page 49, the principal issues a second so-cause notice. Page 49, my lord.
Yes. The show cause notice.
Second so-cause notice. My lord, there is no concept of second so-cause notice. But on what basis he issues a second so-cause notice, adds some more allegations against me, my lord. And then he passes, my lord, the impugned order, page 53. My lord.
Yes.
I'll just read, my lord. Whereas once Sri Mokbul Hossain SK, assistant teacher of Garotu Bihar Secondary School, who was placed under suspension due to various allegations framed against him, and the allegations were inquired by the inquiry panel and also held additional charges against him by the departmental inquiry team headed by District School Education Officer West Kar Hills, Tura on 2/7/18, and found that all the allegations against him are grave allegations which are ultimately proved as true. However, some allegations are acquitted by the inquiry panel. Hence, the penalty of censure is a minor penalty, my lord, is imposed upon him, Sri Mokbul Hossain SK, but in the meantime, his suspension is hereby revoked with the following terms and conditions. So, minor penalty of censure, my lord, I am reinstated in service, but he imposes 7 conditions on me, my lord. He shall have to withdraw all false complaint lodged against the principal cum secretary and against the managing committee of the school with a copy to the principal cum secretary to the school by complaint dated 7/4/17, 22/4/17, addressed to DSEO, complaint dated 7/5/18, addressed to the Honorable Chief Minister, so and so. He shall have to tender a written apology to the principal cum secretary.
You're reading?
Para 2, my lord.
Para 2.
So, secondly, he asks for a written apology from the principal, my lord.
Yes.
Thirdly, he says that give an undertaking to the principal that he shall be sincere in his school duties. Then he says, well, he shall have to withdraw the false case lodged by him against some teaching and non-teaching staff. He shall have to return book something, my lord. So he imposes 7 conditions for his reinstatement, my lord. And this order was passed on 4th September 2018, my lord.
Yes.
But this order, though passed on 4th September 18, was received by me on 26/10/2018, my lord.
Where is yours?
It is there on page 53 itself, my lord, on the left hand side. And there's a statement in the description.
Receive on 2610.
2610, my lord.
Yes.
So, my lord, lordship seen 4918 is 4th September is the order. I received on 26th October after almost 1.5 months. In the meantime, what he does, my lord, page 55, he passes another order, my lord.
Yes.
The principal, and this time he dismisses me from service, my lord.
What was the previous orders? Say it says
Censure, my lord.
censure.
Previous order passes just after order first para and second para. Hence, the penalty of censure is imposed.
Page 54.
53, my lord. At the beginning itself, my lord. Whereas once
Okay.
so and so, the next para, my lord. Hence, the penalty of censure is imposed.
Yes.
And suspension is revoked. So I am reinstated also, my lord. But I received this letter on 26/10/18. In the meantime, he issues another order, my lord, on 21/9/2018, page 55, my lord. And he dismisses me from service, my lord.
Okay.
So I read, my lord.
Yes, 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 please.
Whereas one Sri so-and-so assistant teacher of Garudu Vihar Secondary School who was placed under suspension due to various allegations framed against him, and the allegations were inquired by the inquiry panel and also held additional charges against him by the departmental inquiry team headed by District School Education Officer West Tura on 2/7/18, and found that all the allegations against him are grave allegations which are ultimately proved as true and thereby held guilty on the following allegations of charges.
This departmental inquiry team. What about the composition of this OD?
Well, we don't have access to it. The government can disclose what departmental inquiry was conducted against us, my lord.
Okay.
My lord, first a censure, that is also penalty, my lord. A disciplinary proceedings will culminate with the moment any penalty is imposed, my lord. There is no occasion for him now after 15 days, my lord. And that also I don't even receive a copy of the order, my lord. And after 15 days from censure, he passes a second order and dismisses from service, my lord. And lordship, very interestingly, lordship will see at page 57, my lord.
Yes.
The last paragraph, my lord.
Yes.
It says, on the premises above, it is held the good and sufficient reasons that the continuance of Sri Maqbul Hussain SK assistant teacher in service is prima facie detrimental to the interest of education and discipline of the school, and thereby, in pursuance of the MC meeting resolution number so and so, dated 30/10/2016. Well, this date is of some significance, my lord. 30/10/2016. He passes order on 21/9/18, my lord.
Just one. 30/10/2016. Yes.
With due approval of the DSEO Tura, by memo number so and so dated 4/11/2016, my lord.
Yes.
And as instructed by the District School Education Officer Tura so and so dated 4th November 2016, the service of Sri so and so is hereby dismissed. Now, my lord, to cover up, because he knows that he requires a government's approval for prior approval, my lord.
Yes.
So what he does, my lord, he refers to some letter of 4/11/2016, my lord. Lordship will see the SOCOS notice was issued to me on page first SOCOS notice. My lord, so cause notice itself is issued to me, my lord, on 26 March 2018, page 40, my lord.
March.
Page 40, my lord, you'll see the so cause notice when it was issued to me, my lord.
Yes.
So cause notice was issued to me on 26 March 2018, my lord. Can government approval predate even issuance of so cause notice, my lord? That is the question, my lord. They're referring
Oh,
to
this is 18 and this is 16.
And my lord, I've annexed that 4/11/2016 letter which he refers, my lord. What is that letter, lordship will see at the next page, my lord.
Yes.
Page 58, my lord. This is something altogether different. This, by no stretch of imagination, this can be called as a prior approval of the dismissal from service, my lord. It says, my lord, as resolved by the managing committee of Garoil so and so dated so and so, which is duly approved by the undersigned white number so and so dated 4/11/16, you are directed to held up the pay monthly salary of the following teachers with effect from November 16 until further decision of the MC of the school.
Yes.
And then it says, my lord, my name is also there. Then it says, further you may suspend or terminate the above mentioned teachers which may deem it fit and proper on drawing legal procedure against them, such as explanation, so cause notice, if the involved found indiscipline and illegal activities which are detrimental against the interest of the school without further approval of the undersigned.
Yes.
My lord, in my humble submission, when disciplinary proceedings starts with issuance of so cause notice, my lord, so the approval must be after that, my lord. In fact, the approval will come after the managing committee takes a decision that a particular employee should be terminated. That file should be sent to the government for approval, my lord. Here is a blanket approval of 2016, my lord. So cause notice issued to me in 2018, and first he imposes a penalty of censure. Then within next 15 days he dismisses me from service, my lord. And so, my lord, these are the brief facts of the case. Your lordship has seen how a person who is guilty. Now I've been told, my lord, I filed an additional affidavit in this matter, my lord, bringing on record. What is that?
Yes.
Against the same principle, my lord, the respondent number 4, there were complaints to Lokayukta, my lord, for misappropriation of school funds. But this additional affidavit filed around April 22, my lord, this last year.
Yes.
Lokayukta has taken cognizance of the matter, my lord.
Yes.
And after preliminary inquiry has asked for filing of charge sheet against him, my lord.
Mm.
And I've been told that he was arrested for 1 month and now he's out on bail, my lord.
Okay.
He's still in service. And even that is not understood, my lord. If somebody goes to jail for a month, my lord, and he's back as a principal, my lord, after he got bail.
He was not suspended.
Because he's the boss, my lord, of the school.
Okay. Okay.
He has to suspend himself, my lord.
No, but he may be, but these all these sequence of events are known to the authorities concerned, the DSEO and all.
It is known to them, but government is not taking any action, my lord.
Oh.
Or in fact, in the government's affidavit, they admit that there is no approval to my dismissal from service, my lord. But that clinches the case. There is. Can I just point out the affidavit of government, my lord? But the affidavit filed in the second matter, my lord. Next item. The counter affidavit of respondent number 1 to 3, my lord.
This is dated?
Affidavit, my lord?
Yes.
July 2019, please, my lord.
July.
29 July 2019.
Para 17 of this affidavit, my lords will see.
Para 17.
And this affidavit is filed by the DSCO, my lord, of Tura.
That's him, BG Moin.
No, by this time he changed, my lord. My lord, game is changing with change of DSCO, my lord. Para 17, my lord.
Yes.
Page 5, para 17.
Yes, please.
That with regard to the amendments made in para 30 of the writ petition, the answering respondent states that the dismissal of the petitioner was done by the respondent number 4 and 5 and was done without the approval of the competent authority. The letter of approval quoted in the order dated 4/11/16 appears to be irrelevant and invalid. Therefore, the dismissal of the petitioner is illegal. So this is the stand of the government, my lord. In my humble submission, my lord, and your lordships have dealt with a similar matter, I can just place the judgment, my lord, that require the prior approval of the government in terms of section 9 is mandatory requirement, my lord. And the logical conclusion will be is restatement, my lord, with areas of salary, my lord.
Para?
Para 13, my lord. 13 and 17.
Yes.
Para 13, my lord.
Yes.
Mr. R. Gurung, learned additional senior GA, appearing for the respondents number 1 to 6, has submitted that apparently the respondent managing committee, while passing the impugned termination order, has not complied with the provision of law as pointed out by the petitioner, particularly the provision of subsection 2 of section 9 of the Meghalaya School Education Act 1981. However, it is also noticed that the petitioner has filed a representation before the respondent number 6, and as such, it is further submitted that the attention of the respondent number 6 may be directed to the said representation and dispose it in accordance with law.
So this is a submission of the GA.
So para 14, my lord, lordship's observation, my lord. Having heard the submission of the parties herein, on the face of it, this petition merits consideration as the impugned termination order was passed without affording any opportunity of the petitioner to respond to the allegations made therein. The proper procedure has not been followed by the respondent managing committee, and however genuine the grounds of termination may be, for which the court may not enter into the discussion of the facts therein, the principle of natural justice having been violated, the impugned termination order has to be set aside and quashed. The contention of the respondent number 7 to 9 as regard the eligibility of the respondent number 7 to hold post of headmistress, that's not relevant, my lord. In the para 17, my lord, in the overall consideration of the matter, the impugned termination order dated so and so issued upon the petitioner by the chairperson so and so is hereby set aside and quashed. The petitioner is hereby directed to be reinstated in service. As prayed for by the respondents, are also directed to pay the salary due and payable to the petitioner for the month March to September so and so, and the period from the month of October till so and so so and so. Well, para 9 refers to the rule, my lord.
Yes.
My lord, on this line, there is a series with many judgments, my lord. That rule 9 is mandatory. There must be prior.
That of course.
I can place some more judgments, my lord, if required, my lord, on this. So, my lord, accordingly, my prayer in the writ petition is to set aside the censure termination order also, my lord, to my dismissal order also. Because two penalties have been imposed on me. First censure, then dismissal. I've challenged both, my lord. I've also challenged I've also prayed for, my lord, to implement the 5 recommendation of the inquiry committee, my lord, which gave me the post of principal, my lord. So here, my lord, I was supposed to be principal, my lord, but I'm out for the service, my lord. These schools, what is happening, my lord?
The game of tit for tat.
Very unfortunate, my lord.
But you have not stated, you see, there you pointed out about your censure, punishment of censure, eventual termination. But the process per se of how it came about, show cause being issued to you, whether you are called to, whether charges were framed,
no charges framed, my lord.
all those
No
things.
inquiry officer, nothing. Simply a sober
Inquiry
notice.
officer.
Nothing is there.
Have you made that a permanent?
Statements are there.
So you see, you have you challenged the whole process of your termination or your suspension.
Well, one more interesting fact, my lord. In para 29 of the writ petition, we stated, my lord.
Yes.
Just read, my lord. When the petitioner states that the principal once again through post sent an order dated 4/9/18 wherein it was stated that the allegation against the petitioner was inquired on 2/7/18 by the departmental inquiry and proved it is true, and some other allegation against the petitioners are acquitted by the inquiry panel. The petitioner was imposed the penalty of censure and the petitioner's suspension was revoked. However, subject to the fulfillment of certain terms and conditions, and in event of failure of the petitioner to fulfill the terms and conditions stated therein, the petitioner shall not be treated as reinstated and the managing committee shall be at liberty to take any action against the petitioner as deemed fit and proper. The aforesaid order was received by the petitioner on 26/10/18. It is aptly to mention here that on 2/7/18 the inquiry was held against the principal for a misappropriation of teacher's salary and not against the petitioner. But 2/7/18 inquiry was against the principal, my lord. He is saying that some inquiry, because lots of seen there is a reference to in the termination order, some inquiry panel, my lord. That inquiry panel was directed against the respondent number 4, my lord.
But not against the petitioner.
Not against the petitioner, my lord.
Yes, yes, yes.
Moreover, my lord, after a full-fledged committee, my lord, headed by a extra-assistant commissioner and 4 senior officers from education department, they took a certain decision, my lord. What was the reason to take a U-turn from that, my lord? And that was the process in the right direction, my lord. And there is no reason ascribed for why a sudden U-turn was taken, and where is the government's approval to all that U-turn, my lord? The Mr. Momin and the respondent number 4, my lord, they are trying to run the show in utter defiance to the directions of the government, of the DC.
Yes.
That's my case, my lord, subject to what they say.
Yes, who will respond now?
this is no party. My friend is giving me the.
So-
Most of the allegations are against the private respondent, the principal, so let him clarify the stand.
With Lordship permission. Before I take Lordship attention to my counter, I just refer to a few of the annexures referred from my friend in the repetition.
Yes.
Repetition.
You are for respondent 4 and 5?
Right.
Yes.
But page number 15, 16, and 17. These are the complaints,
Yes.
including page number 18. Of the repetition.
Yes.
Now, page number 20 of the repetition. The managing committee was dissolved on the basis of the allegation made by the repetitioners and other friends.
Yeah.
And the TSO had taken over the management of the school. Page number 21, like my friend has pointed out, this is a complaint filed by one of the complainant, Mr. Raman. And thereafter, my lord, the page number 23.
Yes.
My lord, director has directed the TSO to conduct a spot inquiry. Spot inquiry.
That's,
So the complaint has reached to the director, page number 23.
yes.
And TSO here is supposed to conduct a detailed inquiry, spot inquiry, in accordance with law. But the problem here started from page number 24. The writ petitioners are the robbing the deputy commissioner, who has no jurisdiction. Now, the deputy commissioner has taken over the entire complaint crisis of the school and formed this inquiry committee. There is no law empowering the district magistrate or so-called deputy commissioner revenue officer to take over the management of the school and conduct the affairs of the school education department. Problem lies here, my lord. Now he has formed 5 members inquiry committee. This is absolutely illegal, man.
Yes.
Now therefore, order 20 June 2017. Deputy Commissioner formed 5 members committee.
After this order was passed, this order of 20th June by DC,
Yes,
have you filed any representation or complaint against this?
my lord. Now, after this, the inquiry was conducted. Behind my back, page number 25, inquiry report. This inquiry report committee, 5 members has indicted me.
Yes.
That there is a misappropriation of fund, course salaries are withdrawn. These are the findings of the inquiry committee.
Yes.
Without hearing the principal. According to me, my lord, since the foundation of formation of the inquiry committee itself is not tenable in law, whatever report given by this so-called committee, created by the hand of the deputy commissioner, it doesn't have any legal consequences. My friend is heavily relying on that. On the basis of this finding, there was a complaint before the Lok Ayuktha also, and criminal case is pending. I'll come to that point. Now, I will not go to the finding of the report. My friend has pointed out some part of the findings, and suggestion also. Suggestion is available on page number 27.
Yes.
Suggestion recommendation given by that 5 members committee.
Yes.
Now, on the basis of the recommendation given by 5 committee, page number, my lord, page 29. Deputy Commissioner has again passed an order.
Yes.
22nd August 2007. And I'm really amused, surprised. At least the Deputy Commissioner is supposed to know the distinction between the functioning of the revenue, or so-called the general administration of district, and the education affairs. Now, here is no question of director arise, ST also doesn't arise. He assumed the entire power. Now he passed his order that I should be demoted, salary should be released. These are the and the acting upon the recommendation of the committee. This has no consequences. Now, thereafter, page number 30, on the basis of that report, 5 members report, the Secretary Government has directed the Director to issue show cause notice to the Principal that before you take a notice, before you take action, you have to issue notice, show cause notice.
Yes.
So this was the order passed on 24th. Though the Director has already passed a Deputy Commissioner has already passed an order adverse to me. Now,
this order is okay.
Madam, because the adverse report of the 5 members committee has reached to the government,
Yes.
and government has directed the director. Government is not directed the deputy commissioner to take action.
Okay.
Because the government is very much aware that deputy commissioner has no power.
Yes, yes.
So whatever allegation is there, the government asks the education director to look into the matter by issuing show cause notice.
Okay.
Now, page number 31. Director has issued this letter to the DSEO to issue show cause notice to the petitioner, to the respondent, principal. Page number 31.
Yes.
And page number 32 is the show cause notice. Show cause notice issued to the principal by the DSEO. Though the basis of the show cause notice is not tenable, but anyway, show cause was issued. And this was issued by the committee. Page 32. 32.
Yes.
Show cause notice. Now, before the principal issue a show cause reply,
Just a moment. Yes.
My lord. Page number 33. STSEO, without awaiting the response from the principal, the one who issued notice, he has downgraded the principal.
Okay.
Now see, he asked me to give my reply. He has to wait for my reply. But without waiting a reply from my side, he had issued this order on 8 September, 6 September 2017. Downgraded me.
Is it 8 or 8?
8 September. 8 September.
8 September.
Yes.
So, okay.
8
Show cause
September.
notice was 4th September.
Yes.
Okay.
And my friend was promoted to the post of principal, now which he is claiming. Now he is also trying to stand on the pedestal where, my lord, that promotion was founded illegally. Now
Yes.
he sought for restoration to the post of principal.
Yes. Yes, all right.
So according to me, my demotion is illegal. So also, his promotion to the post of principal is illegal. Because the show cause is still pending.
Yes,
Now my friend has referred to page number 34. These are the salary statement.
yes.
My page number 36. On the basis of the recommendation given by 5 members committee, now DSEO also, page number 36.
Page 36.
Madam,
Yes.
call for formation of new managing committee. Because the managing committee was dissolved on the basis of the complaint given by my friend and others.
Okay.
And the deputy commissioner said, go for formation of new committee.
Yes.
So he issued this notice for formation of new committee. And page number 37, my lord.
Yes.
Page number 37. Surprisingly, my lord,
Yes.
deputy commissioner behaving like a big father out there. He is now interfering with the formation of managing committee. He issued notice, issue this letter to the SP to provide, my lord, security personnel for formation of managing committee. 28th December.
This is only on the aspect of law and order.
Law and order. Law and order. Law and order. No, normally, my lord, if the police
Nothing
is
to do
involved,
with nothing to do with the organization of the the process of constitution of the new managing committee.
earlier background, he has passed an order for formation. Now, normally, if law and order situation require, normally police station is approached, SP is approached. They do. If they fail, normally head of the district administration, DC is to involve. So he issued this letter. No problem. Now, come to my lord page number 38. Now, my friend said that rightly, Mr. Saha was retired, was in the hand of the deputy commissioner, and new DG moment came as a DSO.
Yes.
DSO. He had to re-examine the entire background of the case. And he found that, my lord, the proceeding directed against the principal was in the hands of the wrong person, deputy commissioner, and there was a 5 members inquiry. And no proper show cause notice was given. Show cause was given by earlier Mr. Saha without awaiting my reply. Demoted me, promoted my friend, go for formation of a new managing committee. So because of that, my lord, he passed this order. And this order is very clear, man. On examination of the officer records and found
Pass
that
page
page number 38.
38.
38, man. 38. 38. Annexure. This is annexure, it is not reflected.
Section 19.
Annexure, perhaps election 19. I just read, man.
Yes, yes.
In pursuance to the letter dated Sunset 8 this September 2017, Sri Sunset, the principal of higher secondary, Sunset, who was degraded to the assistant teacher, is hereby reinstated to his original post as a principal of Karutubi Sunset, as per letter Sunset, Shillong Sunset, from the director of the Sunset, Meghalaya Shillong. The reinstatement of Sri Islam Chaudhary, the principal of the school, is done by the undersigned after proper examination of the officer records, and found that the then district education officer, West Garu Hills, Tura, did not follow an official procedure such as show cause notice. The issue show cause notice, no respondent was awaited, an opportunity to place his grievance before downgradation of the person concerned. Letter number Sunset, 8th September, the downgradation of Sunset, and Mr. Hussain promoted to the post of principal Sunset is hereby treated as cancelled with immediate effect. And this letter is page number 33, the one we read out.
Yes.
And page number 39, I'm also not, it is not legible. My friends, I said it is a resolution of the managing committee.
No, 39A is the type copy.
39. 39A is not given to me. Copy is not given to me.
Oh.
So I'm a little bit handicapped on this. But my friend has read out that is a dissolution of the managing committee.
You get a copy from them. Yes. You give him a copy of that page 38 or 39.
And thereafter, my lord, after the new managing the new STSU came and corrected the entire illegal proceedings, the whatever finding given by the earlier 5 members committee, whatever action taken by the deputy commissioner, whatever action taken by Mr. Saha, wipe out. And there was a fresh inquiry. He looked into the matter, and notices were issued to him. May I refer to my counter? Those papers are there. In the petition, it is not a matter. In my counter, page number 10, annexure 1. Page number 10, annexure 1.
Yes.
My lord, this is the receipt of the issued by the petitioner and others. Because in para 5 of the writ petition, that the principal did not release the salary for these people. Whereas, my lord, this is the signature along with the revenue fees, showing that they have received the salaries also. Now, page number 11. This is the letter issued by Joint Director before he became a STSO. He was holding the post of Joint Director.
Yeah.
13 November 2017. And this is quite lengthy. The entire crisis is narrated here. May I read out, my lord?
Yes, please.
Complaint in the matter of obnoxious disbursement of monthly salary of a high school made by the STSO and such. In response to the above complaint in the matter of obnoxious disbursement of monthly salary of the school made by the STSO and such, sport inquiry was done on such and such, and was found the following fact as below. Number 1, it is found that some of the assistant lecturers and assistant teachers of high school, as mentioned in the sport inquiry report in Series and such, are absent from school duty, and there is no signature in the school attendance register. According to information given by the public who were present in sport inquiry, they are always coming to school at such and leaving the school at such without taking any classes. Such kind of malpractices by those unscrupulous teachers are spoiling the life of the students who are reading in that school. Serious action should have been taken against those neglected teachers and assistant lecturers. The school is totally neglected as there is no one responsible person to look after the school administration due to dissolve the existing school managing committee by STSO. Because managing committee was already dissolved by that time on the basis of the C report. It is found that from the reliable sources that the STSO Tura has made payment of monthly salary with effect from 2017 to such August 2017, 8 months to some assistant lecturers and assistant teachers, and still not yet released the salary of some assistant lecturers and assistant teachers. An amount of rupees such only to be released as teacher salary for 8 months to such. It is also found that without proper inquiry and serving show cause notice to the existing school managing committee of the school, and without approval from the directors the legally constituted managing committee was dissolved by 2017. That was the earlier we read out together, me and my friend pointed out already, on the ground of financial misappropriation of the sanctioned money meant for salary of teachers and which money without any proof. So they are referring to the first report given by the 5 members committee. Now the next page, there is no mention how many amount of ad hoc grant in its sanction by the government meant for teachers salary was misappropriated by the existing managing committee of the school. No amount was mentioned. If there is a misappropriation, normally this amount 10,000, 10 lakhs, 5 lakhs is misappropriated. There is nothing. Lordship may keep in mind. And the Joint Director has noticed this clearly. On spot inquiry conducted on such by the undersigned, it was found that the cash books of Karotupi Higher Secondary School, with effect from 2015-2017, has already been audited by the Director of Local Accounts, Meghalaya Shillong. There is no any audit objection. It's very important. Here in this petition as well as Lokaikta, my lord, and now the criminal case. They are standing on this. Therefore, this is the finding. No objection in respect of ad hoc grant in aids received by the school managing committee. Then from where the DSEO Dura has found out the financial misappropriation of sanctioned money meant for salary of teachers and management. The Meghalaya higher secondary and upper management rules, page number such, Meghalaya such, the inspector of schools have the power to dissolve and reconstitute the managing committee in the school at any time, but this is in subject to two conditions. Number one, the circumstances must be so demand, and this must be so subject to the approval of the director of public instruction. If an existing management committee has to be dissolved due to some allegation against it, the principal natural justice would demand that they should be apprised of the same, and appropriate opportunity should be given to them to their say in the matter. But an appropriate opportunity is not given to the school managing committee to place their grievances before dissolving the school managing committee, such. I therefore hereby directed to release the salary of assistant lecturers and such, the school kept in your account, and reinstate the legal accounts with the school managing committee of the school, which was dissolved early as possible. He has passed his order. So with regard to number two, 2 points I could notice. One is with regard to misappropriation allegation, the finding given by the earlier 5-member committee. What is the amount of misappropriation not highlighted? It is incorrect. Number two, dissolution without giving notice is incorrect. Therefore, he has resolved. The joint director has resolved this crisis. And thereafter, my lord, the page number 13, the spot inquiry report, a copy, it is there. And I may just take to lordship the page number 16. Page number 16. 16. This is the spot inquiry found by, my lord, prepared by the joint director, and he found that one on the basis of that he passed that order. I'll just point out the relevant findings he placed on record. Point number 10 is the observation remarks. On the spot inquiry, it was found that the DSEO Dora, without proper inquiry and serving show cause notice to the school MC prior to take steps for dissolving the MC, and without the approval of the director, the legally constituted MC was dissolved for simple complaint made by the assistant teachers of the school, by my friend, my lord, and others, and not by the public, for misappropriation of school fund. SDO Dura has also failed to mention how many amount of school fund was misappropriated by the SMC. The SMC should be given an opportunity to submit a detailed report against the complaint made by the teachers. It is found that the cash books of secondary section and higher secondary section of Karutupi School from 2015 to 17 had already been audited by the Directorate of Local Accounts, Meghalaya Shillong, and on account balances in the cash books have also nil. There is no any audit objection found in the school cash books. Now the question of misappropriation of fund by the school managing committee of the census does not arise at all on record. Now, despite of this, my lord, one of the person went to Lokaikta, espoused the cause of the petitioner here. Now, this petition was filed in 2018. Now, the Lokaikta, surprising 2020, my lord, filed a complaint petition before Lokaikta. And that complaint petition contained of 22 paragraphs. And out of the 23, surprisingly, 23 paragraphs, 3 to my lord, 22 are lifted from the petitions. 3 paragraphs are introducing himself as a public spirited person. Now here the competent authorities say that audit was done. There was no adverse finding. SDSU did not give a clear finding that what was the amount of misappropriation. So this is a wild allegation. It is not in accordance with law. There is nothing is there. Despite of this, my lord, they went. They obtained the order from the local Ayuktha. Now case is registered and case is going on. Therefore, I was explaining in the morning regarding those 3 criminal petitions, urgencies there, my lord. Now this is the finding. Now recommendation, my lord, I may not take, my lord. Legally, he asked for reconstitution.
Okay.
Now, thereafter, my lord, what happened? The inquiry was formed, page number 17. Shall we continue tomorrow or day after tomorrow, or shall we proceed? Okay. We will take some more time. And this is the first petition we are going. Remaining 6 are still there.
We will continue next week.
Next.
Well, I have not gone to Lokayukta, my lord. Why my friend is referring to, I don't know.
He has
It's not
filed
me that I have gone to
additional
Lokayukta.
rejoins
It's
and he has a
not, it's not my
next.
complaint. He becomes a principal, I have no problem, my lord. He becomes super principal, I have no problem. Just I've come only for reinstatement of my service. My lord.
He is relying on the complaint.
Why is taking to here and there, my lord, I don't understand.
It appears that the whole, there's a lot of
What government is doing, my lord, I don't understand that, my lord.
lot of confusion going.
Government
continue next week, my lord.
Government's inaction, my lord, and is encouraging these kind of people, my lord.
Let's see whether the government is encouraging me or encouraging my friend.
It'll be interesting to note what is the role of the DC now, how he has taken cognizance of the whole.
My lord, my lord, I'll point out who are the members of the committee, my lord.
No, it doesn't mean maybe
Additional
complices of Prime
Director of
Minister,
Education, my lord.
but the authority of
True.
And has he challenged any of those orders, my lord? He's bound by those orders, my lord.
It was then
When he was
submitted by
downgraded, did he challenge that order before this honorable court? No. When the committee was constituted, has he ever challenged? Now, when additional director, my lord, I believe he's quite at a higher pedestal than the district school education officer. A decision of joint additional director, my lord, DSEO comes and reverses everything, my lord.
And he is not challenging that reversing order. My lord, my lordship.
I'm
we
challenging
continue
that
next week.
reversal order. That's what I'm challenging.
Next week.
Parties,
some major inquiry, my lord, against these people.
heard parties, heard letter counsel, senior counsel appearing for the petitioner. Also heard letter counsel, senior counsel appearing for respondent 4. Matters is kept part heard to continue on next date fix. As submitted, list is matter to 1 week.
If those criminal petition may be listed after this, because this matter appears, your lordship, I'm here, so it will take time. Your
Criminal
lordship.
petition has nothing to do with this, my lord.
My
Here
lord,
I've come for
After the
enforcement of
disposal
my
of all
registry.
this petition, your lordship.
my lord, I just submit. If the prayer of my AAG, my friend is accepted, lordship proceed this matter decided. And when the criminal cases come, we have to reopen the entire case of these petitions. Because the entire basis of the complaint before the inquiry.
That is a criminal case for misappropriation.
Magistrate court or Lokayukta is based on these petitions. Therefore, to save the time of this honorable court, once the lordship here together, everything will be easy.
Let's put it on the same day, and then if we can, if we can dispose.
I could make out from the submission of my learned senior friend also that there is a, he has referred to the report of inquiry that there is no misappropriation, something like that. So if that be the case, your lordship, then he can go and file a discharge application before the learned trial court, your lordship. Why to keep this criminal petition pending here? Can file if any adverse or does order is passed against, he can always the door of section 482 before your lordship is always open.
Is a prosecution is serious matter.
Well, what
As
report,
lordship
my
pointed
lord,
out,
my lord,
whether
what is
we
that
will come
report,
up
my lord?
together.
I'll point out in that report I was going through, my lord. The report says drawing of double salary is not a heinous crime, my lord.
No, I don't know. There is a finding given by the audit authority. There is no such.
But I think in all this, it appears the proper procedure was not followed. You see, there may have been, some, perhaps a case of misappropriation. There may have been a case of, what should I say, exerting your position illegally or irregularly. All those things may be there. But the procedure it appears was not followed from both sides.
Maybe from both sides. So Lordship may appreciate and maybe take together.
Okay, we'll see how it goes.
Just listen on the same.
What is the interest in tagging together? I don't know. But my case is.
Hey, it doesn't matter. It doesn't matter.
My case is very independent. I come only for
Even if it is tagged together or
wants
not.
to extract some benefit out of the present proceedings.
No.
That in my humble submission cannot
All
be
the
done.
petitioners are the witnesses. They have given a statement, and the same statement is coming lifted from the petitions. So the petitioner Lokayukta is planted by the petitioners only.
I can't understand these submissions.
Untuk last paragraph no fix for fix. So after 1 week. All those things to criminal list.